today. Again, I suspect most of you are familiar with his work, but he is a well-recognized national thought leader on constitutional law in the Supreme Court. He's testified before Congress. He has advised federal and state lawmakers. He is a professor at the South Texas College of Law in Houston and the author of 3 books, including an Introduction to Constitutional Law with Randy Barnett. And he's here with us tonight to discuss the future of the conservative legal movement after Dobbs. So with that,
thank you so much. It's a treat to be here. My first time speaking in Delaware after Widener. So it's good to be here. I have a small task today. Cover 100 years of Supreme Court history. Ready? Okay. So currently we have what's been called the most conservative Supreme Court since the New Deal. I'd like to jump back and sort of walk forward from how we got from the New Deal to the present, and specifically with an eye towards a big case that the court decided last year, Dobbs v. Jackson Women's Health Organization, which overruled Roe versus Wade. So let's start with the New Deal. All right, it's often said that there was a conservative Supreme Court. That's somewhat exaggerated. In many regards, the court was opposed to the agenda of Franklin Roosevelt and the agenda of many state courts, but it wasn't making up new doctrine. This has been fairly well established, the idea that the federal powers were limited, the idea that the states could not violate due process without giving some consideration to the effects. So you have cases in the 19-teens, the 1920s, and 1930s, where the court pushed back against a lot of these sort of newfangled progressive legislation. But as we all know, President Roosevelt sort of won that battle in the long run. He appointed 9 people to the Supreme Court. 9. He had the entire court under his own thumb, which is sort of remarkable. That's what happened since George Washington, who appointed all of them at the very beginning. But then for about 20 years, the court was sort of at this period of stasis, where you had all these Roosevelt appointees who bickered over this and that, but they all generally agreed on big picture issues. Then we get to the 1950s, and with Republican President Dwight Eisenhower, the great general. And he came to the Supreme Court, he came to Washington with a chance to transform the Supreme Court. He did not do that at all. In fact, he made some of the worst picks in American history. So the first one came with Chief Justice. Fred Vinson was Chief Justice. He died suddenly from a heart attack. And Eisenhower said, I have an idea. Let's appoint a California governor named Earl Warren. Now, what's not known is that Earl Warren, again, was Republican governor. Roosevelt was afraid of him. Eisenhower was afraid of him. Eisenhower worried that Warren would primary him in the next presidential election. Said, I have an idea. Let's put Earl Warren in the Supreme Court. He'd be less dangerous there, right? He could be out of the way. He won't bother me. And then we all know that Eisenhower won re-election by a large margin. But Earl Warren would become probably the greatest liberal justice ever in terms of impact. A couple years later, Eisenhower appointed William Brennan, who hailed not too far from here in New Jersey. Again, why Brennan? I swear to you, they wanted a Catholic, and he was the Catholic they picked. There was a Catholic seat, and that's who they wanted to put in the court. Brennan turned out to also be one of the most significant liberal justices of all time. The other pick was John Marshall Harlan II. He was a bit of a moderate. I think he was an okay pick. And then Charles Whitaker, who only served in the court for about 5 years. He just couldn't handle the job. He stepped down, and he never really lived it up. And then we have Potter Stewart, who again was somewhat of a moderate, but he had his liberal tendencies. Okay, so fast forward over time. President Kennedy picks Byron White and Arthur Goldberg. The court is slowly moving towards the left. By the time you get to the mid-1960s, there was a solid 5, 6, or even 7-vote majority of the left, depending on how you count it. So despite having 5 Republican appointees, you still had a solid liberal court. Imagine that. LBJ appointed Abe Fortas and Thurgood Marshall to the court, and again, left. By the time you get to the late 1960s, there was virtually only 1 or 2 conservatives left in the court. You had Harlan and you had Stewart. So all these big Warren court cases were always 7-2, 6-3. They were very lopsided. And during this period, the court transformed America. I don't need to even exaggerate that. With regard to criminal procedure, with regard to race, with regard to rights of privacy, they were just making stuff up all along. And you'll notice, throughout this entire time, did Republicans ever say we need to pack the court? No. Did they say we have to strip jurisdiction? No. You even had some fringe people say we need to impeach Earl Warren, and they were sort of castigated, saying we should not be doing this. Just keep that in mind when we look at what's going on today. Not even 5 minutes after Anthony Kennedy resigned, right? We need to pack the court, right? We endured 3 decades of the mistakes of Dwight Eisenhower, right? 3 decades we endured of those judges, and we're still feeling it to this day. But then President Nixon comes into office in 1969, and Nixon has the chance again to transform the court. He gets 4 appointments, 4, in basically one term and change. His first pick is Chief Justice Warren Burger, who was a very prominent circuit judge from D.C. You know, Warren was not, maybe like Warren, I don't know, but his reputation is not that strong. He was a good administrator, he was a good organizer, but in terms of jurisprudence, he was a bit of a dud. The next pick he had was Harry Blackmun, no relation, spelled differently, from Minnesota. As you might know, Harry Blackmun wrote the Roe v. Wade decision, and he was proud of that decision. The other pick was Lewis Powell, the Virginia businessman, Chamber of Commerce lawyer. Again, he was a bit of a moderate, a little bit left, a little bit right, but he was somewhat centrist. And the only pick that Nixon got right was William Rehnquist, who became the Chief Justice later. But then let's go to 1973. We have Roe v. Wade, which I think is perhaps the most important decision of the second half of the 20th century. Probably after Brown, maybe a few others, but it's up there in terms of importance. This was a case where the court invented a right to abortion. I don't need to exaggerate. We're going to invent it. Was it based on the 14th Amendment or the 9th Amendment? They won't tell you. If you actually read the opinion, they don't even say what the basis of that right is. They say, oh, it's in there. It's somewhere. We don't really tell you where. And they created this very elaborate trimester framework. In the first trimester, you can't do anything. In the second trimester, you can do a little bit. And the third trimester, you can do more. This was completely inactive legislation. But the vote was 7-2. 7-2. In dissent, you had Justice Rehnquist, the Nixon appointee, and Byron White, who was a Kennedy appointee, who turned to be a little bit conservative in some regards. But all of the Eisenhower appointees went along with this. Most of the Nixon appointees went along with this, right? And in many regards, Roe was sort of a wake-up moment, a flare, if you will, a distress signal that something is amiss. A backlash formed. Many conservatives, evangelicals, said we need to get rid of this decision, which started a 50-year process. Again, I said 5-0, a 50-year process to get rid of this one decision. Every year from 1973 on, there was a march in Washington where pro-life people came to show their opposition to this decision. That was the sort of the political side, but also there was the legal side, right? It's not enough to oppose a decision as a matter of policy. You have to have a legal movement to stop it. And really, Roe begat, if I can use a biblical word, it begat the conservative legal movement that we know today. We didn't know it at the time, right? Sort of evolved organically. And a lot of political events sort of occurred at the same time, but Roe was really the genesis of this movement. And who were the early players? Well, one of them was Rehnquist. Rehnquist's dissent in Roe said, this is not how judges behave. We should not be inventing constitutional rights out of whole cloth. Another proponent was Robert Bork. He had been the U.S. Solicitor General. He had been a professor at Yale. He'd never hire him today, but he'd been a professor at Yale. He'd be laughed out of the building. And Bork wrote an article saying that a lot of our First Amendment jurisprudence is out of whack. We need to follow the original intentions of the framers. How would they have understood the freedom of speech? It was not about adult dancing. That's not what the First Amendment was about. And then something crazy happened. Ronald Reagan won the election in 1980. And he brought with him a breath of fresh air with regard to the law. His attorneys general, William French Smith and Ed Meese, were giants who started to redirect the policy of the Department of Justice towards law as written. The picks to the judiciary, including Robert Bork to the D.C. Circuit, Antonin Scalia to the D.C. Circuit, represented, we are going to find judges who will be faithful to the law. And also around this time, another revolution happened, very quiet. Happened in the dormitories of Yale, Chicago, and Harvard. I'm speaking about the birth of the organization that's gladly paying for your appetizers here, which is the Federal Society. Now, the Federal Society didn't exist or wasn't started as this monopoly, as this behemoth. It was literally a student org, the same way you have an SBA in your law school campus. That was it. It was a group of a few people at different law schools who were fed up with the way law was being talked about in their classrooms. That there was only this one perspective, the Warren Court is God, and we must worship them. But where was the criticism? Where was the Rehnquist fan club, right? Where was those favoring the views of Justice Harlan II? Who was criticizing Miranda? Who was criticizing the Roe decision? Who was criticizing the Griswold decision? And this movement sort of germinated. At first, they had student conferences at Chicago, at Yale, at Harvard, at Virginia. They started a journal, a student-edited journal called the Harvard Journal of Law and Public Policy. Maybe you have a subscription. You maybe get it in your mailbox every couple months. It's a really good volume. And around the same time, these students who founded it went on to clerk. They clerked for Judge Scalia. They clerked for Judge Bork. They clerked for Justice Rehnquist, right? They clerked for these new Reagan appointees on the court who could sort of build this pipeline. And eventually, Ed Meese, the Attorney General, gave a series of speeches in 1986, very influential speeches, where he challenged the orthodoxy. And he said, we need to revert to a jurisprudence of original intentions. He caused such a stir that William Brennan responded to him. Can you imagine? The Attorney General gives a speech, and then a justice has to clap back. And Brennan went and gave the speech saying that, no, we are not originalists now, right? We do not do originalism. That word didn't even exist at the time, but we're not originalists. We do not focus on originalism. The framers were dead white slaveholders. We don't care what they think. But Meese gave the speech, and he directed that the DOJ would make arguments based on original meaning. This was a big shift. Imagine like a battleship. You can't pivot it on a dime. It takes a very wide berth to go the other way. But Meese, Scalia, Bork, these are our giants. They help right the ship. And we go into the 90s, and we have another Supreme Court confirmation hearing for Robert Bork. But actually, it's 1987. That one didn't go so well. And the reason why was because he articulated a jurisprudence of originalism. He said very clearly, it's not for judges to make up rights. And this was considered such an apostasy that even Republicans voted him down. And who do we get instead? Anthony Kennedy, right? Justice Kennedy, who was a good Sacramento lawyer that Reagan had known for years, sort of slotted in. Lawrence Tribe backed him. The one reason why he probably should not have picked him. But Kennedy got through, and he extended the Warren Court's jurisprudence for 3 more decades. Again, almost every error that Republicans had was unforced, right? These were errors. Brennan, Berger, Blackmun, Kennedy. I can just list. Souter, the next one, right? Souter, that was my next on my list, right? I'm just scrolling down the list. And then we get to Justice David Souter. Now, what's ironic is that the Dems were afraid of him. Ted Kennedy, remember him? He was convinced that Souter would overrule Roe v. Wade. He was convinced that Souter was this rogue guy from New Hampshire, right? He would be this right-wing zealot. Go look at the ads they ran about Souter. But he passed through. So again, we had the chance to replace William Brennan. Who do we pick? David Souter. The picks of these judges were among the greatest failures of the Reagan and Bush administration, right? Most of the policies by those presidents fade long ago, but their justices endure for decades. Then we get to 1991, and Thurgood Marshall steps down. Again, Thurgood Marshall wanted to hang on, but just his health would not let him go. And who do we get? Justice Clarence Thomas. Now, I assure you, if George Bush knew how conservative Thomas was, he wouldn't have picked him. I think this is a blessed accident. He had no idea. He didn't know what the heck he was getting himself into. Or maybe Thomas became more conservative. I don't care, right? But Thomas is a remarkable person. He's born in 1948. He's still not that old. He'll be around for a ways to come. But his confirmation hearing, as I'm sure those of you who are over the age of 35 will remember, wink, wink, right, was brutal. They came out with him against everything. And perhaps his biggest opponent was the guy the train station is named after, which I just realized. I didn't even know this. The Joe Biden train station. Is that right? Yep. The Joe Biden train station. I pulled in the Amtrak. Okay, Biden. And if you actually watch the hearings, Biden asks him all these questions. He says, Judge Thomas, explain to us natural law. And Biden's just so out of his league. You can just tell he has no idea what he's talking about. And I'm not making this up. So Justice Thomas gave an interview for a documentary, and he said, I quote, about Biden, I had no idea what he was asking me. He had no clue. Biden was just going on about natural law and property right. You could tell someone gave him some notes. He was reading something, and it was just garbled. It was just incoherent. And this was Biden circa 1991. It's not even today. This is Biden 30-something years ago. And then the Anita Hill thing happened, and then he barely got through, but he got through. But really, the Thomas hearing was the first time where originalism was on display, where a judge was openly supporting originalism, and he still made it through. He didn't do what Bork did. Thomas eked through. All right. So after the contentiousness of Souter and Thomas, we get a breath of fresh air. Ginsburg confirmed almost unanimously. Breyer confirmed almost unanimously. No one even cared. Orrin Hatch, who was the Senate Judiciary Chair, said, yeah, Ruth Ginsburg, we good, no problem. Right? The Republicans sort of lined up against Ginsburg, who had been an ACLU lawyer for 3 decades, who had litigated every abortion case top to bottom. But yeah, she'll be fine, I'm sure. All right, but what happened also in the 90s? The FedSoc began to sort of develop to become not just a student organization, but this national group. We have lawyers chapters like all of you sitting here in front of me. We have a national conferences, the Mayflower, which attract thousands of people every year. And we have law professors like me, right? Professors who are not afraid to speak what they think. We're a minority, discreet and insular to be true, but I'm allowed to hide on the Amtrak, and hopefully no one sees me in the corridor, but I'm there, I'm allowed to travel. Then we get to the Bush administration. The first term of the Bush administration, no vacancies. Again, according to some people, Bush was an illegitimate president. He should never have been in office. So just think if Florida had gone the other way, you might have had two Democratic retirements, probably Justice Stevens, maybe one other, Justice Souter. Those didn't happen. We did have Justice Rehnquist and Justice O'Connor. Rehnquist was quite ill. He had cancer. He refused to step down. He refused. He did what most justices do, which is die in office. It's all too common, Scalia, Ginsburg, and so on. So you had Justice O'Connor, though. She did step down. Why? It's actually a very sad story. Justice O'Connor's husband had dementia, and she stepped down to care for him. I don't care what you think about O'Connor's politics. She was a good wife. She was a good person. That's a level of commitment to take the most important job in the world. So you know what? I'm going to take care of my family. That I respect forever on that one. The plan didn't work out, though. This is the saddest part. I always get sad when I say this. When she stepped down, his dementia advanced, and he forgot who she was. So he had to be put in a home. He didn't even know who she was at all. And if you ever had a loved one with dementia, they forget you. That's one of the worst things that you can imagine. So I always tear up when my grandpa does. So O'Connor, though, sacrificed her position and stepped down to care for her husband. And then she was actually still alive. I think she's 99 or so today. She was born, let's see what year. She was born in 1930. Yeah, so she's 93. So she's quite up there. She's still alive. She also has brain, whatever you want to call it. It's not really clear what it is. But she's withdrawn from public life. But then we get 2 back-to-back nominees. So George Bush has the chance to make his mark on the Supreme Court. So initially he picks a young lawyer named John Roberts, who had been a judge for about 5 minutes in the D.C. Circuit. Slightly exact. He'd been judged like a year and a half. It was a very short period. To fill the O'Connor seat. But then after Rehnquist died, Bush promoted, if you will, Roberts to the Chief Justice seat. Then he had to pick someone for the O'Connor seat. And who did Bush pick? Harriet Miers. Remember her?
Oh, yeah.
Yeah, you forgot about her. I didn't forget. She's actually still very active in Texas legal circles. She's still a member of the bar in good standing. Why did Bush pick his White House counsel? I don't know. But despite all the efforts of the federal side and other groups to sort of help select judges, complete failure, right? She had never argued any case of constitutional law. She had no background in this area. She was way out of her league. And actually, conservatives rebelled. So who do we get? We got Trenton's finest from right across the river, Sam Alito, one of the greatest Americans. He was from Trenton, but he's one of the good things coming out of New Jersey. That's bad. I am from Staten Island. It's a little bit of a rivalry. Okay.
He's a Phillies fan, too.
Oh, he's a Phillies fan. That's right. You guys all Phillies fans? Is that how it breaks down here?
Yeah.
Okay. I'm a Yankees fan, so what do I know? Yeah, I'm sorry. All right. Orioles, I don't know if you're halfway to Camden Yard already. So just Alito was a second pick. Ironically, the Democrats came out harder against Roberts than Alito, which in hindsight, they have no idea who to oppose. That's just what it proves. But at the time, Roberts had only been a judge very briefly. We didn't really know what his jurisprudence was. And also, Roberts seemed to be very much in the old school sort of judicial restraint, moderate mold. Alito hadn't. So you remember Planned Parenthood versus Casey, the big abortion case from 1991? Do you remember the circuit opinion upholding the Pennsylvania law? Sam Alito. So Alito wrote the decision that was reversed in Casey. So he had sort of opined in this issue 30-something years ago. But after a big effort to fight, Roberts and Alito came through. There was almost an effort to filibuster the Supreme Court judges, but they didn't actually do it, the Dems. They threatened it, but they didn't actually pull it off. John Kerry actually threatened to do it, but then he went to France or something. He didn't actually do it. I think I'm being serious. I think he actually tried to mount a filibuster from France. I can't remember the details, but it doesn't matter. It didn't work. Okay, then we get to the Obama years, and immediately, look at that. When Clinton came to office, 2 Dem judges resigned back to back. Go figure. When Obama came to office, 2 Dem justices resigned back to back. Right? They're just waiting for a Democratic president so they can have someone fill the seat they'll like. So we got Justice Sotomayor from New York to fill the Souter seat, and we have Justice Kagan, who was the dean of the Harvard Law School, and a good dean too. She was a very good dean at the time, to fill the Stevens seat. All right. So at that point, the court was more or less set for about 6 or 7 years. But always, in every case, Justice Kennedy was a pivotal vote. In every case. Lawrence v. Texas, sodomy, Kennedy majority opinion. Windsor, Defense of Marriage Act, Kennedy majority opinion. Obergefell, gay marriage, Kennedy majority opinion. He basically controlled the court. He was in the majority like 98% of the time, some insane number. Erwin Chemerinsky, the dean of Berkeley, would joke, if I could put Anthony Kennedy's face on the cover of the brief, I would, right? Every single case was litigated for Kennedy's benefit. Again, a Reagan nominee decide the fate of our republic. Gay marriage? Yes. Death penalty? No. He would just decide it because that's what he was. And look, Kennedy had a jurisprudence. He had a philosophy. It's based on fairness, equity, federalism, this jambalaya of law and policy that he sort of comes together. But he had something, right? He was a political hack. I think he really believed what he sold. Okay. That was the court's composition for about 6 or 7 years. But things came to a crashing halt in 2016. And that really brings us to our present moment. In February of 2016, not even is that 7 years ago? Could that be right? Justice Antonin Scalia died at a ranch in West Texas. This was the sort of turning point, or I should say the inflection point of our current conservative legal movement. This could have gone one of 2 ways. If a Democratic, at the time, again, Obama was in office with a Republican Senate, had a Democratic justice been confirmed, we would not have Dobbs, we would not have Bruen, we would not have anything. But there was a risk. Keeping the seat open could let Hillary Clinton pick someone even far more liberal. Or, if Republican nominee prevailed, and we didn't know who it was at the time, we can get a conservative judge. So almost immediately after Justice Scalia died, we entered uncharted waters. Senator Grassley from Iowa, the chair of the Judiciary Committee, said, we will not confirm anyone Obama nominates. Mitch McConnell from Kentucky said, we will not hold any vote on whoever Obama nominates. That was an act of intestinal fortitude of the highest order, right? Because every force in the country said, no, you have to play nice. You have to go along. You have to do what we did for Souter, right? You have to do what we did for Ginsburg and Breyer. And for whatever reason, these Republicans grew a spine. They made the decision, which frankly changed the trajectory of the country. The same way that Eisenhower appointing Brennan and Warren changed our country, and that Nixon appointing Berger and Blackmun changed the country, McConnell and Grassley should have their faces etched on a statue somewhere. I don't know where it will be. Not in Washington. Maybe in Des Moines. I don't know. Right? Or Louisville. I don't know. But definitely not in D.C. They wouldn't want it there. It'll be defaced and they'll tear it down like the Saddam statue 20 years ago, right? 20 years. You meant 20 years in Iraq. Time goes by. But they made the decision, we don't care who Obama nominates, we will not hold any proceedings. And in a way, they could have taken another strategy. They could have said, okay, Obama, nominate your guy and we'll just destroy him. We will humiliate him, we will embarrass him, we will attack him, and we'll vote no. At some level, that would have been worse. And we now know it's Merrick Garland, who maybe you're not a fan of now. At the time, he seemed like a decent person. And I think it's actually better. I think it's actually better to simply not vote for the guy than to put him through this sort of hell. I don't know. Look what happened to Judge Kavanaugh, but what do I know? But there was a second half of that equation. Republican had to win the White House, right? It wasn't enough to hold the seat open because if Hillary Clinton came in, she is appointing someone far more liberal than Garland, who again was an old white dude, right? We got someone far worse. So what happened? Well, the evening Scalia died, there was a debate, a Republican presidential debate. And the moderator asked Trump, what do you think about the Supreme Court? That's Scalia's seat. And he comes down and says, you know what? I'm going to pick Dianne Sykes or Bill Pryor for the Supreme Court. Whoa. Trump fools you. He looks like he doesn't know what he's doing, but he knows what he's doing, right? He's wily like a fox, as they say. That evening, he had talked with people who were in the Federal Society. He wanted names, people he could put on a debate. I want these two people. By the way, I wish he had picked Sykes and Pryor over the two he actually picked, but that's another story. They were good. At the time, I was actually working in the Cruz campaign, and I was like, can we put out names? I'm like, no, I don't know if we should do this. Maybe we shouldn't do this. They were kind of hesitant. Trump just went for it. What do I know? All right, so Trump put out those two names, and then shortly thereafter, he put a list. He loves lists. Beautiful, big list, right? A list, a huge list, right? And he put out a list of judges who he would pick from if he were to be elected. This was a significant move because at the time, Republicans didn't trust the guy. I didn't trust. I think he picked his sister, Judge Rendell, for the Supreme Court, right? Not Rendell. What's her name? Marion Barry Trump, wrong politician's wife, right? That's the governor's wife, right? I thought he was going to pick his sister, pick Judge Judy for all we know, right, for the Supreme Court. But when he put the list, I was like, okay, this is the guy. This guy's at least talking to serious people. And these were all FETSOC judges, right? The movement that began in the '80s had helped develop and build a network where these judges were known. There was no more Souter. There was no more Roberts. These were these ciphers. You know who they were. These were judges who were known quantities. You knew what they represented, knew what they would do. And Trump put out a list. By the way, was Neil Gorsuch on that list? No. Was Brett Kavanaugh? No. So again, the list was kind of pointless in hindsight because the people he picked were not actually on the first list. I liked the first list. First list was good. Second list got corrupted by the DC people. It's true. Anyway, so we all know what happened. Trump won the election. Right, again, had that not happened, had we gotten Hillary Clinton as president, I consider teaching contracts or something, right? I don't know. Common law just would not be interesting because what the hell's the point, right? Just flip a coin, might as well. I actually consider, do I still want to teach common law? We have another 30 years of the Warren Court, right? Meanwhile, all the liberal professors are like, we can't teach common law. How are we going to teach this? Roe v. Wade. Anyway. So then we get to the election. Trump prevails. And shortly after the inauguration, he nominates Neil Gorsuch for the Supreme Court. Right, again, Gorsuch is, as Trump would say, he's out of central casting, right? He looks the part, he's got the silver hair, he's perfectly coiffed. Justice Gorsuch told me I need to cut my hair. So, this guy really respects his group, maybe agrees, right? But Gorsuch's like, you need to cut your hair. I'm like, okay, thank you. Even my dad's okay with it now. Okay. Gorsuch. So, again, Gorsuch is picked, and again, the guy being a federal judge for more than a decade, he yelled at me about my hair. He's like, you need to cut your hair. I'm like, whatever. And you have no mandamus over my head, right? But the Dems made a decision. Again, the Republicans controlled the Senate, but it wasn't a 60-vote block. So the Democrats decided to filibuster Gorsuch. Completely pointless move and self-defeating. Why? Because the Republicans triggered what's called the nuclear option. Right, the nuclear option. What's that? They can eliminate the filibuster by simple majority vote, and they did. Let me tell you something. Had they not filibustered Gorsuch, Kavanaugh would have never made it through. The decision to filibuster Gorsuch was an unforced error. The Democrats had to appease their base, show they were fighting. Pointless. Because McConnell's like, okay, and they just nuked the filibuster, and now the block for Supreme Court requires 51. So again, had they not filibustered Gorsuch, we would never got to Judge Kavanaugh. He would have never made it through. He barely got through with 51 votes, with Pence basically breaking the tie. All right, so that's Gorsuch. And he served on the court for about a year or so. But then at the end of the 2018 term, we had the big shift, right? Scalia for Gorsuch, they're more or less ideologically similar, but the court doesn't change too much. But then we get Justice Kennedy stepping down. Now, why did Kennedy step down? There are rumors that Trump cajoled him or persuaded him in part by saying, look, if you step down, maybe we can nominate one of your former law clerks for the job. Who wouldn't like that, right? And the New York Times floated Brett Kavanaugh, who's a judge in D.C., or Ray Kethledge was a Kavanaugh clerk who is on the Sixth Circuit in Michigan. And so the scuttlebutt is that the reason why Kennedy stepped down was there was some sort of understanding. No quid pro quo. We would never say quid pro quo. Never. Especially not in Chancery Court, right? There's no quid pro quo, but there was an understanding. And indeed, everyone said don't pick Kavanaugh. Mitch McConnell said don't pick Kavanaugh. Everyone said don't pick Kavanaugh. He had been Bush's private lawyer, right? His basically secretary. Every piece of paper that went through the White House was on Brett Kavanaugh's desk. The potential for landmines was just staggering, right? There were so many red flags. Also, as a judge, he had voted to, he got mad when I said this, he voted to uphold Obamacare. He doesn't like when I say this, but he voted to uphold Obamacare. He rejected a challenge to the Affordable Care Act on some very narrow standing argument, which allowed the case to go forward. That's whatever. But he voted to uphold Obamacare. So I have an entire chapter in my book about Brett Kavanaugh. He was my last pick. He wasn't the first list. He was added to the second list so he can get picked. Mark my words. Okay. But Kavanaugh made it through the first ringer. There was a second part that almost got him, which was Christine Blasey Ford. It was his high school yearbook and the allegations from his past. Now, fun fact, do you know that Gorsuch and Kavanaugh went to the same high school? They were 1 year apart. It was a prep school in Maryland. They were 1 year apart. Gorsuch had better friends, apparently, than Brett did.
Of course, his mom ran the EPA.
She did, yeah, Ann Burford Gorsuch, right. And apparently, they didn't get along well in high school, and they don't get along well now. So, some things never change. So, we're still high school cafeteria stuff, right?
Kavanaugh clerked here in Delaware. So.
He did?
Yeah.
I didn't know that. That's right. Before he went out to Kaczynski in California. Yeah, it's funny. Brett didn't actually get the coveted clerkship till later. He had to get basically a warm-up. He had his eyes set high from the beginning. But the second...
He handled judicial nominations for the president, so...
He did.
So some of us here dealt with him then when he was, vetting candidates.
Yeah. I used to be close with him. We're not good terms now because I criticize him a lot. So I just it's a little bit rocky with me and Kavanaugh, but it's okay. Well, maybe we'll have a good. I'm young. He's young. We'll be around for a long time. Maybe we'll have a rapprochement eventually. But anyway, what happened with the allegations of Christine Blasey Ford almost derailed Kavanaugh. Hindsight, I hope better if he withdrew. Someone else would have been confirmed just as easily with better jurisprudence. But fate happened. He got through, so he's there for life. So then we have a court that, on paper at least, has 5 conservative justices. But as soon as Justice Kennedy resigned, John Roberts became the swing. And in that year, 2019 and 2020, Roberts was the fulcrum. He was the center of the court. And especially involving a Trump case, the census, right? DACA, right? All these big cases involving Trump, Roberts cast the deciding vote. And he ruled against the conservatives in almost every case. And it came to a crowning head in June of 2020, a month I call Blue June, where in almost every case, Roberts voted with the liberals. And perhaps the most surprising one was actually Bostock v. Clayton County of Georgia. This involved the Civil Rights Act of 1964, Title VII. And by a 6-3 vote, with Roberts joining Gorsuch's majority opinion, the court says, aha, a law passed in 1964 bars discrimination against gays and lesbians and transgender people. That would have been a shock to anyone alive in the 1960s, as these acts were illegal at the time. But textualism. The Bostock case created this sort of crisis of confidence in the conservative legal movement. People like Josh Hawley, Adrian Vermeule, and others said, wait a minute. If this is what paying dues to FETSOC gets us, I'm not interested, right? In other words, if we work our butts off to elect a Republican president and fight for 2 conservative judges in the court, and what we get is Bostock, what's the point? And that was an inflection point again. In my opinion, had Dobbs gone the other way, FETSOC would have not crumbled, but it would have a very hard time justifying its existence. I'll get to Dobbs in a minute. But Bostock really lit a fuse. That if that's what we get, then is this worth the fight? So that was, again, June of 2020. We get to the summer of 2020 again. We're in the middle of the COVID pandemic. Then we get to September of 2020. Then the unthinkable happens. At that point, it looked like, all right, Biden's going to beat Trump. All right, 5-4 majority is not that bad. We can live with that, right? But then Justice Ginsburg suddenly died. She died in the middle of the campaign. Now, again, Trump could have said, all right, let's pick someone after the election. Vote for me, I can pick the right person. Where it says, we can keep the seat open until 2021. That's not something Trump would ever do, right? There was no chance. So Trump says, all right, I'm going to pick someone. And a couple days later, it wasn't much longer than that, he goes to Indiana, 7th Circuit Judge Amy Coney Barrett. She'd been a law professor for many years. I'd only met her once or twice. Fun fact, she was not really even a FETSOC member for many years. This is well known. If you look at her questionnaire, her membership lapsed for about 15 years. She never came to the national convention. Most people never met her till Scalia's funeral. She just wasn't known. I didn't know who she was. I'd never heard of her until she went to the Seventh Circuit. But I think she's actually might be Trump's best pick, and when all said is done, I'll get to that in a few bits. So the Republicans ram her through in October, and they confirm her October 27th, like 4 days before the election. Now, can you imagine just for a second, knowing what we know now what happened after the election, with all the election fraud stuff, allegations, no one would have gotten confirmed. There's no way we could have done anything because everything was in complete chaos for 2 months. We had an impeachment hearing, for God's sake, before the transition. Anyway. But Barrett got through. And with that, you now had a 6-3 conservative majority, exclude Roberts, a solid 5-4 block. No one expected this, right? Everyone thought Ginsburg would hang on and let Clinton fill her seat, or let Biden fill her seat, as it were. But Ginsburg could not hang on for one more day. Ginsburg's decision to not retire during the Obama administration changed history. For all they say that Ginsburg, was a trailblazer, she changed history. Yeah, she did. Her most consequential decision was to not retire. That was it. The decision she cares most about, Roe, she is to blame for it going away. Not directly, but her decision to not retire in 2006 or 7, 2011 or 12, when Obama held a majority in the Senate, was critical. Hubris, I think. I don't know. Arrogance. Scalia didn't resign either. Scalia could resign during the Bush administration. He didn't. So now we have Rehnquist dying in office. We have Scalia dying in office. We have Ginsburg dying in office. A lot of them just die in office. So now let's talk about the 2020-21 period, right? At least in the 2020-21 period, we noticed something called a 3-3-3 court, where you had this sort of three solid conservatives. You had Thomas, you had Alito, you had Gorsuch. You had the court's three liberals, right? You had Sotomayor, you had Breyer, and you had Kagan. And then in the middle, you had the other three. You had Roberts, Kavanaugh, and Barrett. And in a lot of cases, they went left or right. They split up. But the liberals were still losing. The liberals were still winning a significant chunk of the cases. And we weren't really sure where this court was. But then the court grants review in a case called Dobbs v. Jackson Women's Health Organization. This was the case that all the chips were riding. I know you go to a casino, you put all the chips in. This was the all the chips moment. At the time, I wrote very candidly that if having 6 conservative judges can't overrule Roe, then our movement, basically, what's the point, right? If you can't get that, the most obviously wrong precedent, like since Dred Scott, if you can't get that, then what the heck is the point? Why are we having all these lovely appetizers and glasses of Chardonnay, right? Why are we doing all? I don't even drink Chardonnay, right? Why are we doing all these sorts of whatever? I have water. Yeah, whatever. Thank you, Delia Piper. Right? Why do we do all these things if we still have cases like Bostock or Dobbs? And a lot of conservatives actually started writing along similar lines that if the court doesn't overrule Dobbs, it will not just be a failure for the court, but a failure for our movement. And it would have, I think, crumbled. So then Dobbs is argued. And then something crazy happens. We know now that Justice Alito was assigned the majority opinion. And he wrote a draft opinion that overruled the Roe decision. Then somehow, we don't know how, the court's investigation didn't find anything, the opinion leaked. The opinion made to the hands of 2 political reporters in Washington. We don't know how they got it. We'll never. I don't think we'll ever know at this point. I think it's just a lost cause. The FBI. The FBI was not allowed to investigate because the court didn't want a separation of powers breach. They kept everything in-house. So when you do an in-house investigation, no surprise, they don't find the answer. But then we get to after the leak, the protests began. Every day, outside the homes of Brett Kavanaugh, Amy Coney Barrett, John Roberts, people chanting, screaming, the most awful things. They have young children, these judges. And whatever you care about their politics, I would never want my children to be exposed to that. But, people think politics is everything. But then one protester decided to take things in his own hand. He flew cross country from California with a rifle in his check bag, which you're allowed to do. He had gloves, padding for his boots so he could sneak around quietly. He had duct tape, zip ties. He had spent time, I'm not joking you, going on Reddit asking, I swear this is true, I'm writing a book about assassinating a political leader. How would I go about doing it? He went onto a Marine Corps or some sort of special ops Reddit, which is basically a news group, and was asking questions. If I want to write a book about assassinating a judge, how would I go about writing that book? What tips would you recommend? You can find these messages are all in the indictment. I read them all. He shows up at Kavanaugh's house. He walks in front of the house with his gun in his backpack. Of course, he has a backpack. He's a kid, right? And then he keeps walking. And then he has second thoughts. He calls the police and says, I was here to kill Brett Kavanaugh. I've changed my mind. So, putting aside the actual legal issues, attempted murder, is that an attempt of murder? Did he take the substantial step? Think back to criminal law 1L, right? Is it actually a murder? I think it's actually a hard case, right? But I think he has enough to convict him. He was indicted. But we came this close to having an attempted assassination of a justice. And his intent was very clear. He wanted to stop the Dobbs decision. That's why he did it. He wanted to stop the Dobbs decision. This was such an important issue. So then we get to the end of the term, June. So usually June is a bittersweet month for me for the Supreme Court. I like some decisions, and I don't like other decisions, right? But, sometimes it's okay, sometimes it's painful. But June of 2022 is unique. Conservatives ran the table. Every single issue went to the right. Every one. So I'll walk through them. Dobbs overruled Roe v. Wade. Bruin said the Second Amendment extends outside the home. Coach Kennedy v. Bremerton overruled the so-called Lemon test, right? In all of the big cases, the conservatives prevailed. This has never happened in my lifetime. I'm looking around the table, none of yours either. We go back to the 1920s where we actually saw a term like this, right? And in many regards, this was the crowning sort of achievement of the conservative legal movement, that what started in a bunch of dorm rooms in Chicago and Harvard and Yale 50 years ago culminated in transforming. Lemon test, gone. Roe v. Wade, gone. Second Amendment expanded, right? It took half a century to do this. And it took a series of miracles, right? Reagan's election, right? Clarence Thomas, God bless him, right? George Bush getting 2 picks instead of just 1. McConnell and Grassley leaving the seat open, right? Trump winning the election. The Dems filibustering Gorsuch so that Kavanaugh can get through. And then I don't want to call it a miracle, it's awful, but the last sort of inside straight was Justice Ginsburg dying 3 weeks before the election, right? I mean, the odds of all those things happening, and each had happened in exactly the right moment to get us to our present day, is stunning. That this all happened in sequence over the course of half a century to bring us to our moment today. So then now, where are we going forward, right? I say we, the royal we, the conservative legal movement, where are we going forward? There's no longer a unifying force. It was Roe for the longest time because it united sort of the legal nerds with the policy nerds with the pro-life people, sort of all kind of Venn diagram together on an issue that unites us. There really isn't something else. There's some issues of importance, the Second Amendment, but not everyone cares about guns. Most people living in red states, they can have guns as much as they want. They don't need to worry about the Supreme Court's jurisprudence.
Must be nice.
What's that?
Must be nice.
Move to Texas or get a gun trust. I'm sure there'll be a lawyer here who can help you with that. No, those are actually very good. Gun trusts, you can basically, how these work? You basically give your gun to a trustee in Texas legally, and then you keep it here on his behalf. So the gun actually stays in your house in Delaware. But it's not owned by you, it's owned by someone in Texas. So you're not a legal owner, so the cops come, it's not mine.
Can I tell a little story just because you're
Please.
on the topic? I'm not from Delaware. I own shotguns. And to buy them in Illinois, it takes about a week, from when you buy it to when you can pick it up. And I have a little card that says I can own my shotguns. And I went down to Cabela's here and walked in, and they have all these shotguns and they have all these pistols. And I talked to the guy at the desk, and they had all these pistols. I said, what do you need to buy these? I mean, how long do you have to wait? And he goes, in Delaware, just need to show me your driver's license, and you can be out of here in 30 minutes with a pistol.
Good.
I said, what? And he goes, welcome to a free state.
Yep. Welcome.
So you don't need to go to Texas.
I'll come to Texas anyway.
Yeah.
But what is...
These gun trusts sound a lot like what the sovereign citizens do with their houses.
Oh, by putting the trust?
Yeah.
Their entire law firms, their entire practice creating gun trusts, actually very lucrative. I know a lot of people, this is their practice. But what's the issue? Is it guns? Maybe it's religious liberty, free speech, big tech. There are all these sort of ancillary issues, but none sort of unite the movement. And I think what we're going to find is we've sort of transitioned, where I see as FedSoc has been sort of a resistance movement for 5 decades, and now we're in power. And as often happens, what do you do when you're in power? You don't really know, right? You fight sort of to get like the dog who keeps chasing the car doesn't know what to do when he gets there, right? What are you going to do with it? Since we're now in these positions of power, we have to sort of go on defense, right? One area that's going to be significant is so-called court reform, and I put my scare quotes up here very deliberately, right? Barely after Justice Kennedy retired, there was a movement to pack the court, right? They expand the court. Again, we never tried that for half a century. We kept losing all these bad Supreme Court picks, but as soon as Kennedy resigned, we need to expand the court. They want to strip jurisdiction, which I think is actually very dangerous, right? To remove jurisdiction from the Supreme Court. It won't work. There's no way it works. They want to put term limits. As a constitutional amendment, I'm open, but it's got to be an amendment. You can't do it by statute. They say, oh, well, you can still be a judge, but you'll be assigned to a lower court. No, that's not going to work. The newest one is the ethics code, which, again, it sounds innocuous, but the recusal rules have to be different in the Supreme Court because you can't pick another judge. In any other court, if your judge resigns, you just pull a lottery, draw another one out from the pool, right? You can't do that in the Supreme Court. There's 9. So the usual rules of recusal, they have to be different. So really, all of these sort of areas are to say, I don't know where our movement is going. I have no idea. There's a lot of uncertainty. I think there's also a lot of just sort of infighting about what to do in that year governing coalition. I think the court itself is basically on a trajectory that's pretty straight. Religious liberty will get a lot of protection. I think guns will get protection to a point. I think when you have cases involving can a domestic violence restraining order person still have a gun? Probably not. The abortion cases now get tricky because now they're not based on the federal constitution, they're based on the state constitution. So a lot of these issues have been sort of handed over to the state courts. Many of them are elected, many of them are partisan. So depending which party is sort of in control of the state courts will make a big difference. But I want to sort of just wrap up, I promise to take questions, and sort of reflect that what happened in the last half century is frankly remarkable, that you have this movement that sprung up out of nothing in dorm rooms and escalate to the highest heights of power. So now the Supreme Court has 5, maybe 4 Supreme Court justices who agree with us on a lot of issues. It's frankly stunning. And I hope other groups can sort of look at FedSoc as a way to model this sort of organizational change and how to use the power of ideas to sort of alter our state. And the way things look today is different than the way things looked 10 years when I went to law school, and even earlier than that. All right, I'll stop here. I welcome your questions, and thank you all so much.